Welcome to Hull and Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Susanna Popvic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull in Toronto, here are Ian and Susanna.
Hi, and welcome to Hull and Estates and Succession Planning. You are listening to and watching our podcast, which is being launched on the internet on September 1st, 2009. Well, I am proud and pleased to continue with our mini-series with Jordan Atin, a barrister and solicitor, but heavy on the solicitor. He does a lot of work in the area of wills and estates, is quite famous as regular appearances on Business News Network, and at the end of the day, a great close friend of mine. We are here to, well, unfortunately Susanna's not here to join us, and but we're here to continue on some of our discussions that we've had in this mini-series. And what we have talked a little bit about in the first two podcasts was the control and custody of that important document, the will. Mm-hmm. A, it's an important document, and B, treat it like it is an important document, and C, if something goes wrong, how do we fix it? Right. So we talked about losing the will and so on. At the end of the last podcast, we wound up the discussion on lost will, and today's I want to talk a little bit more about some of the emotions behind valuations of assets in an estate. But before we do that, apropos our expectations that we have to always give some good practice points, before we do that, I'd like to talk a little bit about the idea of a practice point that you have in regard to lost wills.
So I was just going to mention to you about this practice point, and it ties into the idea of lost wills. One of the things that I tell my clients, that if they're panicked about losing their original will, if they ever lose their original will, if they're moving and then they can't find it, they don't know where it is, that they should flip me an email or write a letter or something saying, look, I've lost it, I don't know where it is, I did not intend to destroy it and revoke it. So that will buy them some time till we do a new one. So that's just...
That's good, and I mean, it's so important to have some of these sort of technical outs, because seems on the face of it, when you lose a will, such a crazy rule. Yeah. But the nice thing is that it sounds to me like there are ways to fix it in a short-term, technically basis.
Emergency strategies.
That's right.
Yeah. Yeah.
All right. So what we promised to do was spend a bit of time talking about an estate administration issue that I know comes up with a lot of your clients, and that is the whole question of valuation. And not like tax advice we will never give. We don't give business valuation advice.
That's true.
But what we do is we see the issue surface in many estate administrations. And the illustration is this, that lots of people pass away with a fixed value asset like a GIC. Right. So when you die, you know it's worth $100,000, and that is to be divided as the will says. But if you die with assets that need a little bit of work to determine what they're actually worth, two problems at least arise. One is, what is the best mechanism of valuing it and creating that dollar amount and so forth? And the second is, what are some of the intangible, what are some of the non-business emotional issues that overlay in that process? So I thought what we could do is talk about how maybe we could just talk about sort of unique valuation issues. Sure. And some of the family dynamics that come from it, and then finish that discussion with some solutions. Because one of the things that we pride ourselves on this podcast is not just talk about problems, but talk about solutions.
That's the hard part of these podcasts.
That's right. Well, yes. That's absolutely. So could we explore that concept a little bit? All right, so I'll let you pick the asset and identify one that brings with it some trickiness to its valuation.
Right. Real estate, a cottage.
Great.
Take that classic problem. So one of the things that we often put in a will is we may specifically say to the executors, here's what I want you to do as far as valuing. I want you to go out and get a certified appraisal. And then if we're giving, where it really becomes an issue is where we're giving a party, one of the beneficiaries, perhaps the right to buy it. Okay? So in that situation, what we're going to do, that's going to cause a problem, because at what price does the person buy it, right? So that's sort of a classic problem that we would have with the cottage. And so the will drafter has a couple of options there.
Okay, so let's break this down before we get into the options. So we've got a cottage. It's got special attachment to it for some and maybe not so special for others.
Right.
It can be, all of us know how to value. We can have a real estate agent tell us what it's worth, but ultimately until the marketplace picks the value, you don't know what it's worth. Now, to avoid some of these problems, before the explosion on the valuation process, you say you have some suggestions from a drafting standpoint.
Right.
All right. So let's explore some of those suggestions.
Well, one option is to if you're giving an option to purchase to one of the beneficiaries, one of the kids, for example, what you would do is one option would be you designate that the executor shall retain a certified, real estate appraiser, and will circulate the appraisal to the beneficiaries who may have an option.
Okay, so let's stop on that one.
Sure.
What problems arise, though, when you use that designated appraiser?
Well, one is the executor is the one who's picking the appraiser.
Okay, good.
So if there are already bad feelings, if you've got one kid as the executor and the other kid's with an option, or even that kid, the executor, also having an option, there's the issue of how fair an appraisal is it. I mean, appraisals are by their nature opinions, right? And one opinion may vary from between the value may depend on the opinion of the evaluator, the appraiser, and may also be affected by the terms of reference of that appraiser. So those are the sort of that's a one issue about who's going to select the appraiser.
And costs, of course, are always an element. When you get a certified appraiser, they quite properly should charge more.
Right.
And people expect appraisals, I find, they don't want to pay anything for an appraisal.
Right, like get into the agent to drive by and tell me what it's worth, sort of thing.
Yeah. Okay, so I can see some of the problems that arise, but it's a good suggestion and works well with some families and maybe not so well with others. And it depends, I think, obviously on your particular client and the particular asset.
And one way of getting around that issue, and I don't know if you want to get into that right now.
I do. I'm happy. Excuse me. My allergies are...
Yeah, my allergies are up and down too this week. One option is to say, okay, once you've got that first appraisal, that goes out to the people who have an option. Now, they may turn around and say, I don't like this appraisal. It's too high or it's too low. So what often gets built in is the option of one of the other kids to get their own appraisal. And then what you can do is average it, or you can build in complicated situations where if the appraisals are more than 10% apart, then we got to go get a third appraisal. Now, obviously, if they're not happy about paying for one appraisal, there are problems with giving them the option to get additional ones, but that's a way of remedying. At least you, as the will maker, have set the ground rules for your kids and said, look, this is what I'd like you to do. And then it's a little more difficult for the kids to have a free-for-all. At least there's some structure in place.
And I think that really does create a business-like approach to an potentially emotionally highly charged situation. And that goes a long way in any estate planning. All right, so as we wind up today's podcast, I appreciate that, and I think we'll need to just trouble you for one more podcast because I want to just finish that thought on how we deal with some of these variables and how we can avoid some of the trouble at the end of the day. So thanks again for joining us.
My pleasure.
I know, and we're dragging you through great effort here, and it's much appreciated. And
it's great.
We look forward to our next podcast.
You have been listening to Hull and Estates and Succession Planning by Ian Hull and Susanna Popvic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull and Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.